This is case number 18 CV 17382. This is a trial, post-conviction petition, and both counsel and petitioner are present in Marion County courtroom. I am appearing by video, and I can see the witness chair in the Marion County courtroom. And I've had an opportunity to review the memos and exhibits that have been put forward. Let me ask Mr. Patterson, I see that you have, is it 1 through 14, or help me with your exhibits?
Yeah, petitioner would offer exhibits 1 through 14 at this time, Your Honor.
Is there any objection?
None, Your Honor.
All right, I will receive petitioner's exhibits 1 through 14. And then I saw one exhibit for the state, which is 101, but there are a lot of pages attached to that. I think it's something like 78 pages or so.
That's correct.
Okay, and so you're offering that one exhibit?
That is correct, Your Honor. State offers that at this time.
Okay. Okay, is there any objection to 101?
No objection, Your Honor.
All right, I will receive defendant's 101. Is it anticipated that there would be any testimony today?
Yes, Your Honor. We'll be calling Matthew Johnson, Jr. as a witness. That's it.
Okay. Will the defense be calling any witnesses?
Your Honor, we will not.
All right. Thank you. So we are at the point where I have received all the exhibits as evidence, and so those are in the record and available now. But we also are going to have Mr. Johnson testify. So I'm going to need Mr. Johnson, if you would walk up to the witness chair, please. And when you get up there, I want you to raise your right hand, and I'll give you an oath to tell the truth. All right, Mr. Johnson, under penalty of perjury, do you solemnly swear or affirm that the testimony you will give today in this hearing shall be the truth and nothing but the truth?
Yes.
All right, please be seated. And we'll have you start out by saying your name for the record and spelling your last name.
Matthew Mayfield Johnson, Jr., Johnsson.
All right. Thank you very much. And now, Mr. Patterson, you may ask questions.
Thank you, Your Honor. Mr. Johnson, were you listed as the defendant in Marion County Court case number 14C42686?
Yes.
And what were you charged with in that case?
Unlawful delivery of an oxycodone within 1,000 feet of a school and promoting prostitution.
And in this post-conviction case, are you challenging the constitutionality of those convictions?
Yes.
Were you represented by counsel at the time of the underlying convictions?
Yes.
And how many counsel were you represented by?
About 5 or 6 of them.
Who was the last one in that chain of counsel?
Gale, Rieder.
And during Ms. Rieder's representation of you, did you have a chance to meet with her face-to-face?
No. Well, can you rephrase that? Because I met with her initially when she was initially appointed to me.
Okay, so
to be exact, I had one office visit with her.
One office visit. What about after that? Did you ever meet with her again?
No.
How did you communicate with Ms. Rieder?
Through emails.
And how did that come about? Why were you only communicating through emails?
She stated that she didn't trust me and that I wasn't honest with her in our meetings, and she just felt like she couldn't work with me.
Did you feel throughout her representation that you were able to promptly get a hold of her?
No.
And upon meeting with Miss Rieder, how did you tell her you wanted to resolve your case?
I told her right when she was appointed to me that I wanted to go to trial.
And did you guys start marching towards trial?
Well, at least I thought I was. That's what was said to me in the emails, is that she was preparing for me to go to trial.
And communicating through email with Miss Rieder, did you feel as though you were understanding the things that she was explaining to you?
No, absolutely not. There was a lot of confusion and contradicting things that were said between the emails.
And you have the exhibits in front of you?
Yes, I do.
Attached to your trial memo. Can you look at Petitioner's Exhibit 13, please? Tell me when you're there.
I'm there.
You recognize that document?
Yeah, this is a document from David N. Sweet, a doctor, which Gale Rieder had sent me to.
So did you have a meeting with Mr. Sweet?
Yes, I did.
Okay. Is that the report that he generated as a result of that meeting?
Yes, it is.
Okay. Are you familiar, or can you flip to Petitioner's Exhibit 11 for me, please?
It's backwards, sorry. You say 11?
Yeah.
All right. Here.
There?
Yes.
You recognize that document?
Yes, I do.
Have you read the contents of that document?
Yes, I have.
Did you, at the time of your underlying trial, were you able to have contact with your wife, Jessica Johnson?
No, I was not.
Were you aware of the contents of that declaration during the underlying proceedings of trial?
No, I was not aware of it.
Did you understand how that content could be used as a defense in the underlying trial?
No, absolutely not.
And Mr. Johnson, did you and Ms. Rieder ever discuss uniform criminal jury instructions?
She sent it to me in email, and that was it. She never made a phone call to discuss it or anything. And my understanding at the time was because the emails was coming so frequently that anybody could have sent the email. So I wasn't really understanding why she never allowed me to meet up with her to talk about the actual jury.
So did you understand the possible jury instructions that could be presented at trial based on those email communications?
No.
How did you ultimately resolve your case, Mr. Johnson?
I eventually took a no contest plea. I just gave up, and it had stringed along for so long that I felt like I was backed in a corner. So,
And what was your understanding at the time that you pled in regards to your right to appeal?
well, as a part of my agreement with Gale Rieder, we had a conversation in a hallway where I asked her about the motions that my previous attorney, David Kuhn, had filed. And she told me that those were preserved for me, and that if I took the no contest plea offer, then I will be able to preserve those rights.
So at the time that you pled, are you saying that you thought you had the
Appeal
to appeal?
rights, yes.
And you went over a plea petition with Ms. Rieder, is that right?
Yes.
At the time that you were going over that plea petition, is that when she was making those representations to you?
Yes.
Okay.
It was actually on the initial date that I took the plea that she brung out the plea petition. She never ever talked to me about it in emails.
So I think you touched a little bit on why it is that you pled no contest to these charges. Do you think that you had a right at that time to go to trial? Or
Yeah, absolutely, I did.
You did?
Yeah.
Why did you enter no contest pleas then?
Because I was told if I entered the no contest plea, I would be able to sue Kerry Weiland for taking away my initial preliminary hearing rights.
And what about contact with your wife and children?
She said that I would immediately have contact with my wife and my children, and that I wouldn't be labeled a sex offender. And that was initially what led me into appealing the case, because they stuck me with the sex offender when they told me that they would drop the promoting prostitution to get me to plead to the delivery of an oxycodone, and I would be back at home with my wife and keep children.
You feel as though Miss Rieder coerced you into pleading?
Absolutely. She gave me until 5 o'clock to accept the state's offer, when previously, earlier in that day, I had been explaining to her that I didn't want to take the deal. I was already ready to go to trial, but she would never allow me to put on any type of evidence.
Okay. Just a few more questions, Mr. Johnson. If you understood that you did not have a right to appeal, would you have pled guilty or no contest?
No.
If you understood the possible defense and uniform criminal jury instructions that you had at your disposal in relation to your wife's potential testimony, would you have pled no contest to these charges?
No.
If Gale Rieder did not coerce you, as you said, into pleading, would you have pled no contest to these charges?
No.
Okay. Thank you. Nothing further, Your Honor.
All right, cross-examination.
Mr. Mayfield,
Yes.
you've had, as you testified, a number of attorneys in this case. Is that correct?
Yes, sir.
All right, and you actually communicated with most of those attorneys in lengthy emails. Is that correct?
Yes.
And so it's not unusual for you to communicate with your attorneys in emails. Is that correct?
That's what they put on me. And I was always making an effort to try to meet in person with them. I actually met with David Kuhn, on 3 or 4 occasions, twice actually. And I've met with Jessica Kempfee once, and I've met with Kerry Weiland twice.
With that, you did communicate in emails, and the email address you used were the emails that Gale Rieder was using. Is that correct?
Say that
The
again?
email address you used are the email address that Gale Rieder sent you those email addresses to, correct?
Yes, yes.
All right,
No
I have no
further.
further questions for you.
What kind of question?
Any redirect?
Just
Mr. Patterson?
very briefly, Your Honor. Mr. Johnson, you said that you had an opportunity to meet with Mr. Coons face-to-face.
Yes,
Do you feel that was a more effective way to communicate than emails?
absolutely.
Nothing further, Your Honor.
All right. All right, Mr. Johnson, you may step down now and go back to the counsel table. And as I understand it, the petitioner does not have further witnesses. Is that correct?
With that and the exhibits and contents of the trial memorandum, petitioner is rested in
Yeah.
argument.
Okay. All right, and I'd already heard the defendant does not intend to call witnesses. So, Mr. Johnson, at this point, we have all of those exhibits as documents in the record and your testimony, which you just gave. Now, the lawyers are going to make their closing arguments. Those arguments aren't evidence, but it helps the court understand all of these documents. And with that, Mr. Patterson, you may begin. And I would say that petitioner also has a right of a brief rebuttal argument as well. So, Mr. Patterson.
All right, thank you, Your Honor. For the most part, we'll be relying upon the arguments in our trial memorandum, but as I always do in these cases, I'd like to go over a few of the salient points here in case you have any questions for me. Essentially, what petitioner has done is raise 5 claims. Claims 1 and 2 and 3 or 4 are really just bifurcated claims that have been parceled out for purposes of preserving the right to appeal. And then we finally have 1 additional claim, and I'll go through each of those basically as if they were claims. Claims 1 and 2 discuss that trial counsel was ineffective for failing to properly admonish Mr. Johnson about possible defenses that were available to him, jury instructions in support of those offenses, and the testimony that his wife, Jessica Johnson, the alleged victim in this case, would be willing to present before a jury. Trial counsel knew that petitioner's wife intended to make favorable statements at trial. That can be seen through her file in the declaration. That position, as far as Ms. Jessica Johnson is concerned, still hasn't changed. Can be seen in petitioner's Exhibit 11 that she is still willing to present favorable testimony and would have if she was subpoenaed for trial. Trial counsel throughout the representation, likely in an attempt to shield herself from wasted time, decided to use email as a primary form of communication. I believe from her declaration she has formed the opinion that Mr. Johnson was a difficult client and decided that it was better for her best interest to communicate through email throughout her representation. And quite frankly, that decision is extremely inappropriate. She asked petitioner not to contact her at times so that she may prepare for trial. Also inappropriate to turn your client away when that client has questions about their rights that you're trying to represent moving forward. It's very concerning behavior, and especially when we're dealing with complex legal principles at play, and in relation to Petitioner's Exhibit 13, the evaluation of Dr. Sweet, which the trial counsel was familiar with and understood the concepts within that report. That is kind of summarized in pages 14 through 15 of Petitioner's trial memo of kind of the assertions that are made in that report and the concerns that a trial counsel should have had upon reading that document. This has been given communicating via email is given less attention than you would to average client. And based on Dr. Sweet's report, it should be the exact opposite. This is an individual that should have been given more attention than the average client. Petitioner did not understand how his wife's testimony could be used to defend him against the charges against him. He didn't understand the legal principles that were at play, the jury instructions that we presented to the jury, the mens rea requirements of the crimes, how that testimony would fit in light of his defense at trial in front of the jury. It's clearly ineffective assistance of counsel to ignore a client with these sort of deficits and cast into a pool of email contact only, which was not sufficient for Mr. Johnson to understand the legal principles at play. Those principles are outlined in pages 15 through 16 of Petitioner's trial memo. The prejudice from this is clear as day. Mr. Johnson took the stand and he told you, Your Honor, that he would not have pled no contest if he understood the existence of the potential testimony from his wife, Jessica Johnson, if he understood the legal principles at play, if he understood how those legal principles could be used to defend himself, if he understood the jury instructions and what the jury would be asked to do in light of that testimony. Also, without an firm understanding of those legal principles and the available testimony to him, he could not have made a knowing, voluntary, and intelligent decision to waive his constitutional rights, both state and federal, in order to resolve his case with no contest pleas. Claims 3 and 4 discuss the fact that Mr. Johnson was not properly advised of his right to appeal. I think it's clear looking at the trial court record from the transcripts, as well as Mr. Johnson's testimony here today, which coincide with that understanding of the transcripts. Not only did Mr. Johnson think that he had a right to appeal, trial counsel stated on the record that she told him that. And Judge Tripp was disagreeing with her, and trial counsel fought with Judge Tripp and said, I disagree with you and your reading of the plea petition and your understanding of the laws. What Ms. Rieder, trial counsel, was advising petitioner was erroneous. Essentially, he had waived all his rights to appeal, and he did not understand that at the time that he was entering no contest pleas. As a matter of fact, in the transcripts, I believe what he's saying is, I'm just doing this so I can go home to see my wife and kids, and I intend to continue to fight this, showing that his understanding was that he could, in fact, appeal that based on the motions that Mr. Coons have filed and other aspects of his case. And he was not making a knowing, voluntary, intelligent plea no contest on that basis. It was clearly ineffective assistance to counsel to advise Mr. Johnson that, likely to just get him to go ahead and fold no contest so she could get rid of his case. And on those basis, petitioner is entitled to a reversal and remanding of his convictions and sentences back here to the Marion County Circuit Court for further proceedings. Finally, Mr. Johnson told you on the stand that he felt as though Ms. Rieder coerced him into pleading no contest, which I think also looked in the context of petitioner's third and fourth claim for relief, I believe is pretty apparent on the record. He would not have pled no contest if it wasn't for that behavior of trial counsel. And so for that reason, he's entitled to post-conviction relief on his fifth claim as well.
Let me ask you, from looking at the transcript, do you agree that Judge Tripp told the petitioner that he really, in practical terms, doesn't have a right of appeal?
I think if you look at that the colloquy as a whole, Your Honor, is that yes, there was something along those lines mentioned. However, if you place it into context with Dr. Sweet's report, the representation that trial counsel is making on the record along with Judge Tripp, at some point that conversation just kind of fizzles out. I don't believe that it was entirely clear, especially true given the light of Dr. Sweet's report to individual with some of the problems Mr. Johnson has.
Mr. Johnson testified today, and he had earlier made statements. Let me see. How should I phrase that? How would you agree that the Dr. Sweet's report was done on the issue of aid and assist?
I believe that's why it was done. Yes.
Yeah. Now, what about that report? How would you use it differently than establish that Mr. Johnson was able to aid and assist?
Well, Your Honor, if
when you're saying trial counsel made error here, when she had Dr. Sweet's report, and yet her legal opinion was this no contest plea at this deadline. If we miss this deadline, this plea is gone. And that's, I guess, practically speaking, and I don't think it's legal coercion. It's just, hey, you got a deadline. But how else? Why is it error to receive this report and acknowledge that your client can aid and assist? How else would you use it? I guess that's my question.
Well, and Your Honor, I guess for clarification, are you talking about in general, or are you talking about in relation to specific claims? Because I think
yes. In this case,
yes.
He said if I had this report, and so he's able to aid and assist, but you're saying, well, but there's all this other information here. So how should she have used it if you're saying she made an error by misusing it. I get, and
So
maybe that isn't what you're claiming. Maybe that's
No.
just a bad question.
I wouldn't say it's a bad question, Your Honor, but it's not what I'm claiming. What I'm saying is that, and I think you mentioned my first point, which is if a report is simply to communicate he's able to aid and assist, that report would be about 5 words long. That's not what happens in aid and assist reports. It gives an in-depth psychological diagnosis. It talks about possibility of an individual not being able to process information at the same rate as another individual, that some forms of communication may be better than others. And upon reading the entire report, not just the last sentence that says he can aid and assist, knowing those psychological issues are at play, trial counsel had a duty then to follow through and properly explain things in light of knowing that knowledge. A simple email communication with complex legal principles and not meeting face-to-face, that's the inappropriateness when you understand that this is an individual that needs special attention to communicate some of these issues.
Okay.
That's how it fits
and
in.
that's help. Yeah, that is helpful to me. I guess, and I'll just ask this one. I was wondering if maybe you thought this was a sufficient report that she should have done mental disease defense or something like that, but it doesn't sound like that's what you're saying.
No, that's not what I'm saying, Your Honor. I'm just saying,
Okay?
yeah.
No, I understand that, and
Okay.
saying she should have done more to explain this. Okay? All right. Did my questions generate anything else you wanted to say at this point, Mr. Patterson?
No, thank you, Your Honor. I have a rebuttal argument if I want to address those.
Okay. All right. Thank you. Closing argument for defendant.
Thank you, Your Honor. In this case, our trial memo basically lays things out. The Strickland standards are fairly specific when it comes to dealing with a trial counsel's kind of strategic decisions, and there's great deference given to trial counsel. But the evidence that is presented both in the exhibits today and the defendant's testimony clearly contradicts their claims. I'd like to start with Petitioner's Exhibit 13, page 10. That's Dr. Sweet's report. It's second paragraph down. It says, Mr. Johnson has an understanding of how to work and cooperate with counsel, but he does present a dilemma because he has had significant conflicts with previous attorneys. His claim is that people do not listen to him and do not look at his information. He knows how to work with an attorney, but chooses not to. Further, the last sentence in the next paragraph down, he said he gives up every right after a plea, including not having a trial and not confronting witnesses to have a plea bargain. When you then go back and look through the rest of his petition or his exhibits, specifically Exhibit 8, this is the affidavit of David Coons. They had 2 office exhibits, but then they exchanged numerous lengthy emails. He's communicating in emails with his attorneys while he's saying that he would rather have done it in person. Apparently, every single attorney he has that communicates in email, partly because he's the one sending them, numerous lengthy emails. Further, this is somebody who is clearly demonstrating a difficulty interacting with attorneys of his own volition based on Dr. Sweet's report. When you read Gale Rieder's emails, you'll see it directly contradicts some of the things he said on the stand, such as she didn't want to meet with him. One of her emails says that she canceled their meeting because he was uncomfortable meeting private.
That's a lie.
Further from that, you have emails where she specifically explains concepts that could be no clearer, but are very easily explained in writing, such as the fact that he has no access to a preliminary hearing when he's been indicted. And yet, even here today, he's talking about bringing suit about preliminary hearing. And as any attorney would know, it's easier to protect oneself when you are communicating and writing, and you're dealing with that in writing. Just like the appellate issue, where she has, in her emails, in the plea petition, in the court record, told him there's a very limited right to appeal. You have to appeal on colorable issues. Nowhere in there does she say you were going to get and win an appeal on the lack of preliminary hearing or any of the other issues he raised. Instead, she told him you have a very limited ability to appeal. And that's what was signed in the plea petition. As for the remainder of what's been alleged here, this is a defense counsel who very clearly went through all of the evidence. If you look at the police reports provided, they're lined out. She's looked at the evidence that's presented there. She has considered what is available, and she's provided an assessment to the defendant of his chances at trial, which were bleak, to say the least. This is a defendant who testified today that he wanted to go home and see his kids, and quite frankly, the only way to do that was to plead to a deal that allowed probation. And one of the other things I'd like to mention very briefly is, so Defendant's Exhibit 101, kind of Sub-Exhibit 11, which is how I received this from Gale Rieder. The second paragraph in that email, Ms. Rieder replies, "I did get the affidavit from your wife. Oregon law does not allow an attorney to use an affidavit in trial. It's no use to me. In fact, because it contradicts some of your wife's earlier statements to the police, it could actually hurt your case if I try to use it because it looks like she's now making up a new story to help you." In the context of this reply,
I can save you from prison, but you must be willing to enter a no contest plea to the delivery of an oxycodone charge. The DA will recommend probation. If you do so, you will be back with your wife and your family, and the charge of promoting prostitution will be dismissed. There's no doubt that the text evidence together with the pills you had proves to a jury that you were trying to sell the oxycodone to Nicholas Peterson. You will be found guilty of that charge. Why?
That Uncle Frank said I got a good car.
Sorry, we're gonna go backwards real quick because they're not actually kicking down the truth. They're not actually. I'm saying Gale Rieder was ineffective at her legal counsel, even in these emails, and Sean Callery should be ashamed of himself, especially due to the fact that he's running for district attorney for Hood River. Now, if the community of Hood River knew that this man did this illegal thing for the Marion County DA's office, then it would be a whole different story. And that's something that I'm going to dive into right after this. I pay for my mistakes. Society has given me a second chance, and I plan on clocking on that second chance to proving that what they did to me is wrong. So what we're going to do is rewind it. See, Sean Callery ain't reading all of the emails. He's reading partial emails, and he's not showing where the actual coercion is. And you will hear in my court audio transcripts that the public defender, Coben Patterson, is trying to make that aware. You will see that. Sorry. And thank you guys for actually watching this take place here, because this is very important information that we putting over here. What we really doing is reading my actual legit emails versus the ones that Sean Callery is reading off of his 101 page exhibits. See, one thing that I'm concerned with in this whole thing is the fact that if you actually getting a copy of an email, it should still print off from its letterhead. The letterhead should never disappear. Everything is like missing. Like when you compare the original emails to the emails that they got, it should be the same. My copy should look exactly as the original, but here, if you paying attention, Douglas Hanson and Marion County done deleted the Gmail off the Gmail server where these emails came from, who was obtaining them, because the thing is that the teleport tells on them, like everything that they did to me. He's not reading. Let's listen to him real quick.
Exhibit 101, kind of sub-exhibit 11, which is how I received this from
Which
Gale
is
Rieder.
how he received it, right?
The second paragraph in that email, Ms. Rieder replies, I did get the affidavit from your wife. Oregon law does not allow an attorney to use an affidavit in trial. It's no use to me. In fact, because it contradicts some of your wife's earlier statements to the police, it could actually hurt your case if I try to use it, because it looks like she's now making up a new story to help you.
Now, I have to pause it right there, because he's not going to continue to read on record the rest of what the email say. So we're going to help Mr. Sean Kellery out, because Sean Kellery, you running for Hood River DA, but you ain't telling the truth about how you harmed an innocent person. So listen to this. I can save you from prison, but you must be willing to enter a no contest plea to the delivery of an oxycodone charge. The DA will recommend probation if you do. You will be back with your wife and your family, and the charge of promoting prostitution will be dismissed. There's no doubt that the text evidence, together with the pills you have, proved to a jury that you were trying to sell oxycodone to Nicholas Peterson. You will be found guilty of that charge. Why not? Why not plead no contest, get probation, and be done with this nightmare that has come into your life? There will be no restrictions on contact with you, with your family, and you will not be labeled a sex offender. I know you continue to be upset because you did not get a preliminary hearing. Pleading no contest to the drug charge does not mean that you cannot pursue a civil suit against Kerry Weiland if you want to. Think this over. We can resolve this case and end this now. Gale Rieder. See, Sean Callery, he's not going to read the whole email. This is what they trained to do, though. They don't want to give the information fully. They want to pick out what they saying, and he trying to cover himself by saying he didn't do it. It came to him by Gale Rieder, but Gale Rieder retired. How is Gale Rieder even playing a part in this case? Retired. But I'm saying that Sean Callery knowingly know that this is the job of the district attorney, DA Douglas Hanson, who he once worked for. So the conflict of interest is that they all know each other. I'm not never going to get a fair trial, and people ask me this question. What you want me to do about it? What you want me to do? You want me to suit up? You want me to go to war? You want me to do this? No, I want people to be aware. I understand that this has happened to me, but that still shouldn't silence the facts here that, hey, even though that they illegally did this to Matthew Johnson, let's change it up. Let's make sure that we put whistleblowers, whatever we need to make sure that the DA is held accountable for his unethical misconduct. There shouldn't be a clause that supports the DA's wrongdoing, especially if he's making a personal choice to crush the Constitution, in which we all know that you got to take an oath of office and you got to swear by that oath of office that you will uphold the Constitution. Right, wrong, or indifferent, if a person is innocent, you let that person go. If you got evidence to formally prosecute that person, and that person wishes to go to trial, allow that person to go to trial. Sean Kellery was put on this job to do a bad job, and he now trying to leave Marion County DA's office due to the scrutiny. And I think whoever the public is, whoever organized that, should take a look at my information and please share it with them, because I got questions for them. Who gave you wrongful information but didn't tell you that I spend a tremendous amount of time explaining and exposing the truth? You can't halfway read a document. And that's what he's doing. He's just picking through the whole document. To me is important. You know what I'm saying? But if I go up, what's it? Let's go up. I'm gonna use this side. I'm gonna use his 100 because this email right here is contradicting right here. This email is to give you an update on the research and trial strategy planning that I've been doing for your case. I have reviewed all the materials, including all the materials provided to me by David Kuhn. Those materials include some reports about your physical condition at the time of your arrest and your interview on June 18, 2014 of your wife, Jessica Johnson, by Pamela Bilderback, an investigator for the public defenders of Marion County. I have considered whether to file motions to attempt to prevent your wife from testifying, because under Oregon Revised Statute 40.255 OEC 505, husband-wife privilege, this rule reads as follows in pertains partner part 42.5 Rule 505 husband-wife privilege as used in this section unless the context require otherwise. In any criminal proceeding, neither spouse during the marriage shall be examined adversely against the other as to any other matters occurring during the marriage unless the spouse is called as a witness consent to testifying. There is no privilege under this section A in any criminal action in which one spouse is charged with bigamy, which me and my wife was not charged with, or with an offense of attempted offense against the person or property of the other spouse committed in the course of committing the attempted committing an offense against the other spouse. Now, I had this on silent all the time. we most definitely gonna dive in to this paperwork. Okay, that was cool. I didn't have it muted. So, since I got at least one viewer, please stick around and listen to this contradicting statement. But I want to read the rest of this before my phone call. See, the devil always got a way to try to stop you from getting your truth out. But, you know, God uses his vessels properly. And when I say that I know for a fact the devil don't want God's people to win, because the world is already filled up with hate and all that. But I'll leave the preaching for another day, because sometimes I really feel the Holy Spirit takes over me when I'm talking about this situation. But here in this particular situation, when we're talking about the contradicting emails and the ineffective at counsel and how Gale Rieder is confusing me, we hear my public defender Coben Patterson talk about how she just meets me through emails. I was never allowed to put on no evidence. How could I put on physical evidence through emails, right? So in her own words right here, Gale Rieder said, this privilege applies and we can likely keep Jessica from testifying because under the facts of your case, it is unlikely that a judge would consider her a victim. So if the judge wouldn't consider her a victim, how can the district attorneys consider her a victim? How? When my attorney is but again, I'm going to shut up and I'm going to press play on this real quick.
In her emails, in the plea petition, in the court record, told him there's a very limited right to appeal. You have to appeal on colorable issues. Nowhere in there does she say you were going to get and win an appeal on the lack of preliminary hearing or any of the other issues he raised. Instead, she told him you have a very limited ability to appeal. And that's what was signed in the plea petition. As for the remainder of what's been alleged here, this is a defense counsel who very clearly went through all of the evidence. If you look at the police reports provided, they're lined out. She's looked at the evidence that's presented there. She has considered what is available, and she's provided an assessment to the defendant of his chances at trial, which were bleak, to say the least. This is a defendant who testified today that he wanted to go home and see his kids. And quite frankly, the only way to do that was to plead to a deal that allowed probation. And one of the other things I'd like to mention very briefly is, so Defendant's Exhibit 101, kind of Sub-Exhibit 11, which is how I received this from Gale Rieder. The second paragraph in that email, Ms. Rieder replies,
second. What about the
I
third?
did get the affidavit from your wife. Oregon law does not allow an attorney to use an affidavit in trial. It's no use to me. In fact, because it contradicts some of your wife's earlier statements to the police, it could actually hurt your case if I try to use it because it looks like she's now making up a new story to help you. In the context of this reply is sent, it's clear she's responding to an email. So his claim that he didn't know about the affidavit is clearly incorrect because her response is, it's not helpful, and it's not helpful specifically because it looks like she's making stuff up. And that is an accurate assessment of that response, given that when you look at the police reports where she says, yep, he's here to help me out, he stays in the closet to protect me when things get rough, gives him most of the money. And then she later says, well, he had no idea what was going on, even though he actively was caught in the closet when the officers arrived. You have a very clearly fabricated story. So what you don't have is ineffective assistance of counsel on Ms. Rieder's part when she's assessing the evidence. You don't have an inability to communicate that to the defendant because she's told him about it. You don't have ineffective assistance of counsel when it comes to the appeal because she has told him repeatedly in her emails that some of his appellate claims are not allowable. She has told him on the record that it has to be a colorable claim. She has had him sign a plea petition that says it is a very limited right to appeal. They talk about it on the record briefly. And in the end, what you're left with is this idea that the defendant's claim that he was somehow unaware of what was going on is just contradicted by the evidence, which brings me to the final assertion that his desires were completely overborne by the defense counsel in this particular case because of the deadline. Defense counsel's declaration makes it clear she didn't set the deadline. The state set a deadline
Don't blame
on a trial
Gale.
that was ready to go. If you read the rest of her emails, she says in one of them, your choice is whether to go to trial or not. You have this choice, but here's the evidence we're facing. This is what you're looking at if you get a sentence. This is the deal that you have, and you need to decide by this date. All of those are statements of fact. They are not coercion or any kind of undue pressure that would prevent this defendant from making his own choice, as recognized by Dr. Sweet's report, where he has the ability to aid and assist. He has the ability to sit and understand things, and emails are a perfect way to communicate with
No,
him
it ain't.
because he has it in writing. He can read it as many times as he needs.
That's a lie.
In short, Your Honor, there is no evidence here that there is any ineffective assistance of counsel.
Oh, yes,
or,
it is.
That ineffective assistance of counsel would lead in any way to a different outcome in this proceeding. Thank you.
He's a lie.
All right.
Let's see what
any rebuttal argument.
Just shortly, Your Honor.
Yeah.
Yeah, first, in relation to opposing counsel's representation of Petitioner's Exhibit 13 on page 10, that's about 3 sentences of a 10-page report that's focused in. It's ignoring all of the other
Show list.
information that's contained with that report that I was speaking about, both in my trial memo and
Yes, it
orally
is.
here today. And I will just note that when Mr. Callery was going through and saying this was communicated, this was communicated, this was communicated, that was all followed by email, by email, by email. And I think that in the context of Petitioner's Exhibit 13, knowing that those problems do exist, whether or not he could communicate with an attorney in person, as Dr. Sweet's referencing, completely irrelevant to communication by email. I'd also like to point out that by saying that trial counsel went through all of the evidence very carefully and was making an assessment that was providing effective assistance of counsel. Unfortunately, what opposing counsel is missing is that when you're looking at post-conviction claims in the context where pleas have been entered, it's not about what trial counsel was doing behind the scenes. It's about what petitioner knew and understood at the time that he entered his pleas. So I don't care if she provided the best assistance anyone's ever seen reviewing police reports and stuff. If that was not communicated to Mr. Johnson, he wasn't able to make a knowing, voluntary, and intelligent decision to enter no contest pleas, and that was not providing effective assistance to counsel. Certainly in relation to Dr. Sweet's report, which is Petitioner's Exhibit 13. So quite frankly, I think that defense counsel's argument falls flat on its face. We'd ask that you grant post-conviction relief at this time.
Of course, I lose the post-conviction relief. The thing is, we want to show the ineffective part of Gale Rieder. And, you know, there's videos that I've obtained that I've released on several occasions, but it came to a point where I'm putting the puzzle together and I'm saying to myself that, like my attorney said cold-heartedly, that they skipping important stuff that I'm saying and they just focused on what this prosecutor, Sean Callery, was told. He went into this thinking that he was going to win because he knowingly knew that it's going to get denied. Why my appeal is being denied with all this evidence being put on record by attorneys that's supposed to be representing me and protecting my constitutional rights. Like I said, I don't have any rights. I have to keep on fighting and putting it out there. And we was in a group. I want to share this real quick. We was in a group on the Clubhouse, and it was me and my wife, and we was explaining what was going on, and these people claim to be people that support, want to lend their hand and want to give, but they right off the bat assumed the worst. They thought that I was looking for donation, can you cash at me type ordeal, or I was this person that was full of infested game, and that I was looking for somebody to manipulate, when really they didn't know that Jessica was my wife, because when we go into these meetings, we go in on our own applications, right? So they began to trial us as if we committed a capital hate crime. And as we shared our story, we took a lot of hits, right? We took a lot of publicity hits. We took a lot of negative criticism, and I admit some of it was positive, which leads me to what I'm about to say next, is that fact that even though this person, Jen, was so aggressively like a shark on me, right? She actually was stating some facts like, okay, I'm sorry that you guys went through this, and this is a deep struggle for you, but what do you want us to do about that? We're just here to listen, and we're trying to keep a positive vibe. And but in the beginning, it was like school. In the beginning, we was like sharing the story, and I explained to him like how powerful my wife was, and they allowed her to pray for him. Just the whole thing began to crumble as they figured out the struggle that we were stuck in, right? And it became more of not them supporting what we needed as far as just a listening ear, but they began to criticize and just what question us as far as, what do you want us to do? You want us to go riot like the white folks in Washington, and you want us to da. And I admit, I got out of my character, and I'm like, yeah, let's do that. Is you ready to do that? Because if you read my bio, you would see what I was reaching out to the clubhouse for, right? But they don't have no understanding of it, because I said to them, if you not going through it, then you would never understand it. If you haven't felt the pressures of how hate feel, and you have no way out, and you try to reach out to your county commissioners, your state legislators, your representatives, the Oregon State Bar, the Department of Community Justice, all these different people, and you go down the chain of command, and they keep constantly silencing your voice, then you will get an understanding of how much hate you are enduring. How much hate do the black man or woman have to take? That's what I say. That's what I say. Like I said, you learn a lot from the clubhouse, but certain individuals on there don't understand that it's a situation where people come and they share their testimonies, and they give their stories, and they pretty much open themselves up to this world of a whole bunch of different mindsets, a whole bunch of different, everybody want to have a say, everybody want to be the moderator, everybody want to, have the keys to the car, everybody want to be this leader, and people just jumping in and over talking people, and they partying, and they kicking game, and they kicking knowledge. But when they hear real knowledge and game, and then you direct them to go to where it is, and you say, hey, look it up for yourself. Let me not be the one to show you anything, right? Go on your own time. We all use a smartphone. I don't care if you've got an iPhone or Android. Some apps still apply. You still got YouTube. You still got Google Chrome. You can go and research what a struggle really looked like. You talk about the George Floyd incident. Take your knee off my neck so I can breathe. How much hate do one family have to endure before the word justice even apply? And I say this to say it because when we were in this clubhouse meeting and these people questioned us and they tried to figure out, how do you have this? Can you do this? Are you getting government assistance? What do you expect for us to do? What in my bio it said my goal, right? My goal was to bring awareness, to make sure the next black person, the next black man don't have to go through this. And I get a lot of emails, right? I get a lot of what they call inbox messages. I get a lot of those things, right? Uh, of people asking me about the law, asking me if I can help them. And then I sit in my carnal mind and I say to myself, I'm struggling just the same as the person that's calling me for help. I'm going through the struggle too. I'm not receiving no help, my Lord. Why is that? But at the same time I begin to say to myself that God has used me in a way that allow people to understand that he is real, that he's there, that if you accept him, you will be able to follow the path in which he led. And I'm not the type of person that's going to throw Bible verses on a person to get them to believe in God. I'm not the type of person that's going to throw the Bible on you. I'm going to tell you cold-heartedly what he has done for me and how he's cruising in my life and the things he's exposing
Mr. Johnson.
to me. I do a lot of work, and I think if people pay close attention, they will allow the shackles to be released from me and my family. But sometimes that's too much to ask for, because a person that ain't going through a pressure situation will never understand how to get out of that pressure, what it takes, especially if you're an entity, a state employee that use an office for personal gain, and you take advantage of it by manipulating, stealing, falsifying, and doing all the rest of the cricket dirt that mounts up to corruption. That's why I said how much hate I began this long journey a long time ago, right? But before it all, I would hear something speaking over me. And that voice at the time was my mom, right? She would tell me, "You on a long, dark, black road to hell." At the time, I admit, I didn't understand what my mom was saying. I had no clue of the rocky road ahead of me. One thing that I did know is that I had faith in God. I believed in Him. I knew there was a higher power. You know, you go against what you know is wrong. You go against it because you want to test it to see if you can get away with it. And then when this bad thing happened to us, we want to begin to blame God. But we're not checking ourselves when we doing hateful things behind the scenes, when we talking hatefully about people. And I spent 7 long years fighting this case, putting it out there to the public, saying that I'm innocent. What they've done to me is clearly on the record, shows that it's ineffective at the legal counsel. It's ineffective at everything, right? And I start saying, I got to stop blaming God for this. But what I got to do is accept God into my life and allow Him to direct me and use me as the vessel. Allow me to put the evidence out there. Allow me to show people what I'm talking about. Because I believe that when God sends you help, you don't have to ask for it. You don't have to go and say, "Hey, I need you to do this. I need you to do that." Because God will provide that. That is the preaching saying, is that God will provide you the help. God is the necessarily one. He's the one that oversees it all. He's the one that puts you through the struggle, take you out the struggle, and we blame God. We blame God for His teachings. We blame God for not coming on time to us, not giving us what we need when we think we need it, not when we want it. I mean, not when we want it right then and there. You know what I'm saying? My focus, that, like I said, I was on this meeting in this app called the Clubhouse, right? And these people is real sharks. I mean, and what you got to understand is, in this world, I get it. A lot of us are struggling. A lot of us is going through things. A lot of us got something to fight for. But a lot of us ain't getting the help that we respectfully deserve. A lot of us is being overlooked by the hatred that the devil put out there on the world, that I don't want to help you because I want to be the one shining over you. I don't want to get on your movement with you because you're not making sense to me. Well, like I tell people, and this, it affected me more so than it affect my wife, because I was thinking, like, y'all will wait until a person leave y'all room and then y'all will still put on a secret trial. Y'all would corrupt, and y'all would talk, and y'all would be in agreement, but here y'all is talking about how Donald Trump is wrong and the things that he do. Everybody It's in this life that I'm beginning to understand, and that's why I say, stop blaming God. Stop blaming God. Nobody want to get deep with it because they know it's true. You can preach, but let your financing go down. Let your house go down. Let everything go down, and let everything in your life go away. And then you begin to think to yourself like, God, why you take it from me? Why you take it from me? What's up, Jessica?
You irritating.
No, that really, huh?
No, it's my husband. There's this new app called Clubhouse that I just found. So we've been kind of on there just exploring, getting off Facebook and whatnot. So he's in here. It's the one where